would like to welcome everyone for the final session of the 5-day FDP on contemporary issues and changing facets of law. The broad theme of the session is appointment of Constitutional Court judges, need for an overhaul. For that end, I would like to welcome our esteemed and learned speaker, Professor Dr. Vijay Kumar, who is currently the Vice-Chancellor at National Law Institute, University, Bhopal. I also welcome our officiating Dean and Head of Department, Professor Dr. Komalodich. We all know that judiciary is an important organ of the government, and in a constitution which provides for separation of powers between the center and the state and independent judicial system, the role of the judiciary becomes much more crucial. Since our constitution was enacted, the judiciary has performed a vital role in interpreting and protecting the constitution whenever any sort of dispute has arisen. Since the Supreme Court and the High Courts have such vast power and functions, the judges who sit in these courts have huge responsibilities on their shoulders. Hence, they must be appointed through a process that is just and fair, without any bias, so that the working of these courts can be carried out in an efficient manner. In light of that theme, this session becomes extremely important. Before I hand over the mic to Professor Vijay Kumar, I would just like to introduce him. Sir has a PhD in International Law and Constitutional Law from University of Madras. He was appointed as an assistant professor of law in 1988, as an associate professor in 92, and professor of law in 1997. Prior to joining NLSIU Bangalore, he was teaching at the Presidency College Madras. He was the registrar of NLSIU between 2005 and 2008. During this time, he also administered the UNHCR Chair on Refugee Law between 1997 and April 2018. He was awarded the Ryoichi Sasakawa Young Leaders Fellowship at the Salzburg Seminar in 1993. He was visiting scholar with York University, Toronto, at Canada, at its Center for Refugee Studies during 2000 to 2003, and was exchange visitor at the National University of Singapore during 2004 to 2005 under the Asian Law Institute program. He was a member and vice chairperson of the Board of Governors of the Asian Law Institute located in Singapore National University till 2009. He has served as the Vice-Chancellor of the Tamil Nadu Dr. Ambedkar Law University, Chennai between 2010 and 2013. Sir has published more than 50 articles in national and international journals. He was Chairman, Undergraduate Council between 1997 and 1999, and of Postgraduate Council between 2003 and 2005 at the National Law School of India, University, Bangalore. He was also a member of Karnataka State Higher Education Council between 2012 to 2016. His area of specializations include constitutional law, administrative law, human rights law, law of elections, refugee and Indian law. He was a senior professor of law at National Law School of India, University, Bangalore, before joining NLIU Bhopal as its director. He is currently the Vice Chancellor of NLIU Bhopal. Sir, over to you.
Yep. Thank you. Good afternoon. My sincere apologies for joining late. There were technical and other issues involved. Break for lunch, but having promised to address. Can you hear me now? Can anyone respond?
Yes, sir.
Yes, sir.
Okay. Oh, good. Right. As they are all, you're all faculty members, I would like to appreciate whenever you have doubts, whenever you have questions to ask, please, I would appreciate you can raise the question. I would like to assertive rather than one-way presentation. Right? Is it clear? Okay.
Definitely, sir.
Right. Yeah. Before I speak about the appointment of judges, why is it important? And why is it very important in the context of contemporary developments? When I say contemporary developments, not this year or previous year, but almost from 1995, right? The first Skora judgment effect, right? So therefore, I need to take you around to another basic concept which is totally related to the appointment of judges. That is, why is it that appointment of judges is very important in the working of the Indian Constitution, or for any other liberal democratic constitution for that matter? It is important because there is an old statement Qui custodium ipso custodiae. It's a Latin phrase which means who will watch the last watchman, or who will guard the last guard, in whatever language you want to put it. Who will watch the last watchman, right? The constitution of every democratic country, starting from the US down any other country, and India is an exception, where they treated the judiciary as the last custodian of the constitutional governance. And therefore, they have given the power to review the law, the power even to review the constitutional amendments, right, which possibly may not be available in the US Constitution, right? And even judicial review is not directly available in the American Constitution. It was brought into the functioning of the Constitution through the judgment delivered in 1803. I'm sorry, 1703. In a mob, the question of review of the laws or the amendments is not mentioned anywhere in the text of the Constitution, including those 27 amendments. And therefore, if this is the reason why the judiciary is called as the custodian and the last watchman, and therefore we need to keep them at a very high pedestal, respect them, regard them. At the same time, if you just allow them to function the way they want, they can also become one more dragon in the working of the Constitution, and therefore their power is to be checked, right? So there are two concepts that I want you to keep in mind. One is judicial independence. The other one is separation of powers, right? And within these two branches, with these two themes, I would bring in the appointment of judges, right? Now, when you look at this Latin maxim that I mentioned to you, Justice Untwalia, or Antwalia as you pronounce, in Union of India versus Sankalchan, the first cases in judicial, right, 1977 Supreme Court, right, in which Justice Untwalia held that judiciary is a watching tower above all the big structures of the other limbs of the state as to whether they are working in accordance with the law and the Constitution being supreme, right? So who will watch the last watchman? He has put it in a beautiful manner. I once again repeat that judiciary is a watching tower above all the big structures of other limbs of the state as to whether they are working in accordance with the law and the Constitution being supreme, right? It's a beautiful statement, but there lies the question also. What if the Supreme Court itself commits something wrong? What if the Supreme Court itself does something against the written provisions of the Constitution? Who will watch them? Who will guard the last guard, or who will tell them that they are doing wrong? And that is the place where the doctrine of separation of powers and checks and balances come into picture. Let me just start with the independence of the court. Because of this important position or status given to the Supreme Court for being the last watchman in the working of the Constitution to supervise all other branches of the government, right? The independence of the judiciary is an essential part of it, right? If they have to perform these tasks, right, one among the highest tasks given in the Constitution, then they must be independent. The moment they become committed, then I think the entire Constitution, the entire edifice will fail. So therefore, they have to be independent. And therefore, I want you to very carefully look at the two phrases that I am going to tell: independence of judges and independence of the court, right? These are phrases often substituted or interchangeably used by writers, right? Which is wrong in my opinion. I may be wrong, but I would rather put it: independence of judge is different from independence of the judiciary. Independence of the judge in one sense, where the judge can, stay well ahead of all other members, not subject to any sort of influence, right? I don't want to describe what influence would mean, direct or indirect, and is able to deliver judgment according to his own conscience, number one, according to the constitution and the laws, nothing more than that, right? That is called as independence of judge. I'm not going to talk about that. But independence of judiciary is something much more superior to the independence of the judges, because it is a collective concept. Independence of the judiciary, it's a collective concept. As it is a collective concept, the judiciary must be independent of the other two branches of the government. That is how I look at it. It must be independent of the other two branches, the executive branch and the legislative branch, right? And thereby it is able to perform, or it is permitted to perform, what is mandated of the Supreme Court and the High Court under the Constitution, right? Now, if this independence is to be maintained, we have to look at the Constituent Assembly debates, right, to find out what compelled them to provide such humongous set of powers to the court, right? And what makes them independent, and how it is to be organized, etc., etc. So I have a few questions on the independence of the judiciary, right? I'm trying to explain what independence of judiciary would mean. So first question is, what is this independence? That I have already very briefly mentioned. Independence from the onslaught of the executive and the judicial branches, right? Interference by the other two branches in the working of the judicial branch. Number two, why is it so important? That also vaguely I mentioned to you, the judiciary being the last watchman. The third question is, why is it relevant in the present day context, right? It is relevant. I hope all of you must have seen an interview of the former Chief Justice of India, right, to one of the news reporters. I think, if I remember right, NDTV. And the very plain and straightforward question was asked by the Campia: is the judiciary corrupt? Right? There have been newspaper clippings right from the past 20 years. Chief Justice saying 1/3 of the judiciary is corrupt, and after a few years, 50% of them are corrupt. And now the former Chief Justice, when being interviewed in the public channel, he was mentioning that corruption is as old as this society, right? Therefore, you cannot, the judges are also members of the society, you cannot exempt them. I don't know. He didn't say that, but I'm only trying to, assume that what he was intending to, right? Therefore, is it relevant in the present day context if every one of us is interested in the autonomy, the independence of the judiciary? We need to very clearly safeguard that status as independent judiciary. The moment it becomes vulnerable to any form of corruption, be it monetary, be it influential, be it something else, personal, right? Then I think the very autonomy and the independence will be questioned or challenged, and therefore it will be a big blow to the democratic governance in the country in the years to come. So therefore, there is a huge obligation imposed on the judiciary to be like this. And therefore, I asked this question also, and I'm putting it as a question: if it is the ultimate authority, should it be accountable at all or not? Right? Should it be made accountable in some form or the other? Right? If it is not accountable, then I think anyone can become dictatorial. Right? Yes.
Sir, it is often stated that they are accountable in the court of public opinion.
They are not accountable in that sense at all. Their accountability is somewhat different. Anyone can claim. Can you criticize the judgment made by the given by the Supreme Court?
Sir, we can criticize the judgment,
You
but
can,
not.
no, there is a difference. You can critique it, but you cannot
Yes.
criticize it.
Yeah, we cannot criticize it. Yes, sir.
Right? So you can critique it. You are an academic, you are a political science teacher, law teacher, or you are a learned citizen. Right? You can critique the judgment saying that the judgment for following reason is not able to stand up to the provisions of the Constitution. Yes. But are they accountable to each and every citizen? In my opinion, that is far-fetched argument. Right? They are not accountable to every citizen of this country. They may think so, but they need not do so. There is vast difference between these two. They may think so, but they need not do so. Right? So what is this meaning of judicial accountability? And how this accountability is being ensured? So these are all things we need to look at it. Then only you will understand and appreciate why the appointment of judges. I even today, I know nothing. I know none. But I still look at the orders issued by the ministry appointing somebody as a judge or the High Court, or transferring somebody or appointing somebody as the Chief Justice or to the Supreme Court, so on and so forth, to find out what they are doing. Is it appropriate? Is it good? Is it correct? Right? So these are the questions that come to our mind, and keeping this accountability in focus, accountability of the judiciary, because it is some sort of control is very, very minimal, but accountability should be there, right? When and where exactly judicial independence begin and end, that also needs to be addressed. When the judicial independence begin and when does it end, right? Then only we have to understand everything. Now, when I go back to history, Sapru Committee recommendations of 1946, right? They discussed about how the judiciary should be. I will not get into it. And the draft Article 103, which is now Article 124 of the Constitution, right? And then there were diverse views expressed by the members of the Constituent Assembly, right? Now what the Supreme Court has said, concurrence, consultation, right? They also said the concurrence must be there. Some of the members also said they must be elected by Rajya Sabha. Somebody said they must be elected by both the houses of parliament. But these were all discussions, right? After all the deliberations, what we need to refer to ultimately is that Article 124 of the Constitution as far as the Supreme Court is concerned, how they are appointed. And there are number of other provisions also, right? In terms of their appointment, in the salary, conditions of work, right? So on and so forth. But 124 is the key to the what you call as the appointment of the Supreme Court judges. And by and large, the same thing applies to the judges of the High Court also is certainly there, right? I'll come to that appointment little later, because the appointing authority is one and the same for both of them. The process is little different, right? Okay. Jawaharlal Nehru, I just this to your notice, as a member of the Constituent Assembly, right? And as the Prime Minister, between 1947 to 52 in the interim government, right? He made a mention in the Constituent Assembly when Article 103 or 124, the present 124 was being discussed, right? Particularly on the appointment of judges. I want you to carefully listen to me. Of the highest integrity, who should be appointed? He says, of the highest integrity, people who can stand up against the executive government and whosoever may come in their way. What a beautiful statement, right? Now, immediately you try to look at 2022. Is the statement of Nehru true, real? Can we check this? Then I think you may get a different answer altogether, right? So in the appointment of judges, you have to find people of the highest integrity, right? And if you sacrifice that integrity, then I think the entire edifice falls. And not only that, people who can stand up against the executive government, and not only executive government, whosoever may come in their way. And that is the way in which Nehru wanted the judges to be selected and appointed, right? The tricky situation is how to identify whether a person is having absolute integrity or not, right? Or whether he knows the spelling of integrity at all or not. How are you going to, ensure this? It is only hearsay, right? Okay, this lawyer is good. This lawyer is very honest, sincere. He doesn't fleece the client, right? He has been paying income tax properly. You collect the information from different sources and come to the conclusion. Yes, please. I see Ajit Singh.
Yes, sir. Sorry to interrupt you, sir.
No,
But
there is
as
no
you
need
said,
to.
you talk about integrity, and there is an expression there which says rule of law, not by rule of man.
Yeah.
But how can we avoid that humane factor? Because the one who makes the law, legislator, the one who apply the law, the one who interpret the law, they are all humans, sir. So
Yes.
how can we avoid this thing? That humane element, how you can avoid it? That is bound to happen.
Okay.
I mean, even the judges.
Yeah, I fully agree with you, but it is not that it is difficult, right? And when people commit mistakes, after coming to judiciary, if they commit mistakes, then certainly there are methods through which they can be made accountable. I'll come to that, right? And that is a place the parliament has utterly failed us. In 1992, 93, 2 years time, if you try to recall the first removal procedure against a sitting Supreme Court judge, right? You remember who I'm talking about? People from Punjab must be knowing it. The first removal procedure under the constitution in the year 92-93. Justice V. Ramasamy, right? That was the first instance where the proceedings began, and they call it as impeachment. It is not impeachment. That's why I said removal, right? Removal of the judge. It was V. Ramasamy. The charges were leveled. 14 charges were framed, and all the 14 were proved by the committee, right? And when it went for voting in Lok Sabha, one party gave a whip asking them not to vote and abstain from voting, right? And then he was saved. Wonderful. He has been saved. But what is the damage that you have caused to that institution? That he can do anything and get away with that, right? This instance was the case of what is that? The West Bengal judge, Calcutta High Court judge,
Soumitra Sen.
Very good. The Rajya Sabha inquired and a wonderful volume of the report, right? Saying that yes, he cannot continue as a judge, he must be removed. And then the House of Lok Sabha, right, had to pass the resolution with the requisite majority. It went on Monday morning. It was slated for discussion, and the then Speaker Meena Kumari, if I remember right, she made a statement that the judge has resigned. The judge has resigned, and the president has accepted. Till Friday evening, judge did not resign. Right after that, he sends a fax message to Rashtrapati Bhavan, and see the speed in which it has been accepted by the president, and sent back to him that your resignation is accepted. You are no more a judge. And then the message is sent to the Lok Sabha, and the resignation has been accepted, and there is nothing remains in this, process, and the matter is dropped. Now this is another mistake coming to Parliament. First one was abstaining from voting because it requires a special majority to remove somebody from office. So if you abstain from voting, you are performing a function you are authorized to perform, and you do not want to perform. That itself is a crime, right? So with the abstention of a particular party, they could not get the majority, requisite majority, 2/3 majority, and therefore the resolution failed. In the second one, the first house convicts or commits, and the second house has to only pass a resolution. Can resignation be a solution? Is a question, right? I would like to bring to your notice Warren Hastings was the Governor General in India, right? Particularly Calcutta first, right? And then he amassed wealth And after retirement, he went back to England. After so many years of his retirement, impeachment proceedings were taken against him. It took 11 years for the House of Commons to pass the resolution convicting him that he is, being a corrupt member of the service. And the matter went to the second house, the House of Lords. They also took 2 years. By want of one vote or so, it failed. Now, what does it say? The consequence is not important. That a person, whether he is inside the service or outside the service, is immaterial, right? But the purpose of impeachment or removal is, once he is removed, he can be given certain other conditions. He or she may not be entitled to contest any office, political office thereafter. That itself can be a limitation. He cannot get his pension, can be a limitation. So therefore, removal comes with some sort of punishment on those individuals who are sought to be removed, and therefore impeachment proceedings can begin even after somebody has retired long ago. If you get the facts now, you can certainly proceed against him, and that is what happened to Warren Hastings. But in this case, he submits the resignation on Friday evening. The president approves it, and Monday morning, see the speed in which, if somebody says the government of India cannot work faster, right? This is an evidence to prove that the government can work faster than you think. And Monday morning, the speaker reads out, the resignation has been accepted. I will just raise a question which is not relevant here. What if Soumitra Sen has said, after the resolution has been adopted by the Lok Sabha, in around 10 o'clock or 10:30, Soumitra Sen says, I have not sent any resignation. What would happen? You got the point? It was sent by fax, and reply also comes in the form of fax. Now any miscreant can play the role in between, right? And if he says, I have not resigned, which he, till Friday evening he was saying that he will never resign, but he did resign, what would happen to that entire proceeding? Can you close it? So there is a failure to ensure accountability of the judiciary. That's what I'm trying to say, right? Failure to ensure accountability in the judiciary, because we have reposed the highest faith in them. We means we the people of India through the constitution, right? We have reposed so much of faith, and therefore it is certainly accountable, and that accountability has failed. And again, the third judge, Justice Dinakaran, right? An initiative was taken, but he had submitted his resignation before it could fructify, before the charges were framed. And when somebody advised him, he went back to revoke his resignation, right? It put the entire Ministry of Law and Justice, out of context, because they did not know what to do. In civil service, if you submit a resignation, within 1 month you can revoke it. You can ask it to not to consider. But can a constitutional functionary do so? Right? Ultimately, they convinced him to quit, and the resignation accepted finally. Right? These are all the methods and manner in which you cannot, ensure accountability.
Sir,
I'll give you one more example. Yeah, I'm sorry. Yeah.
sir,
Yes,
one
sir.
question. Yes, I remember watching the Soumitra Sen hearings when he presented himself before the Rajya Sabha. So one of the arguments that he had raised during that time was that since no judge of the no judge has been impeached till now, and I remember Arun Jaitley got up and said that that does not mean that you cannot be impeached. So they were very well cognizant of the fact that they have that power. Now, I think the problem comes that in case a judge is impeached, then what happens to all the judgments that he had rendered till that point?
No, that is very simple. That is very simple. Even if somebody is disqualified, unqualified.
Is there some sort of a hesitancy as far as the process is concerned to take it to its conclusion? Because then all the judgments come into question, whatever he has already rendered, and those cases can be opened up again.
I don't think so. They will not be opened up once again. If they want to prepare an appeal or revision, they may do so, but they cannot challenge that judgment, right? Assuming that he is competent enough to deliver judgment, he has done the work. Impeachment or removal process is something different. So that will not invalidate the judgments that he or she has written. Right? Okay. So this Sapru committee report and other things, I will not get into the details, right? What is this accountability? Just, I'm sorry, Dr. K. Munshi, right, in the Constituent Assembly, believed that the primary ramification of functional judicial independence would be on the need to ensure fixed salaries. Once an appointment is made, the process of removal and post-retirement employment of judges. Very beautifully summed up A to Z by Dr. Munshi, one among the important members of the Constituent Assembly. Right? All these things you will see provisions of the Constitution today. I will not guide you through each and every article, but you can go through. I'll reiterate once again what it means. T.T. Krishnamachari, right, who was also another member in the Constituent Assembly, cautioned the Assembly not to get carried away with the idea of independence, as that it would result in a judiciary which would become an imperium in imperio. Right? They see the wisdom of these people. Don't give so much of power without accountability to judiciary. If you did that, it would become an imperium in imperio, operating as a sort of superior body to the general body public. Right? And probably what is happening some time ago in the judicial decision making is what is said. I think it has become a reality, and I think we need to look at Krishnamachari's statement once again. Right? Then everyone, Justice, Mr. Poker Sahib also made a mention, and finally, Dr. Ambedkar, right, about the consultative process. I just want to mention this because that's also a point which I wanted to discuss on the appointment of Chief Justice. Dr. Ambedkar said, the incorporation of consultation with the Chief Justice of India in the Constitution, hence, not in any way a concession of the fundamental nature of the power of appointment. It was rather a necessary check to ensure merit, since conventional checks such as those prevalent in the United Kingdom had yet to develop in India. What a beautiful statement of Ambedkar, right? And Ambedkar also felt that seeking the concurrence of the Chief Justice India, somebody asked the question, how a judge could be an angel. Everyone is a human being, whether he is a legislator, whether he is an executive or a judge. We are all human beings and we are bound to commit blunders, right? And please look at the statement of Dr. Ambedkar. I think I am responding to the question raised by Ajit Singh, right? Dr. Ambedkar mentioned seeking the concurrence of the Chief Justice of India would be giving him a veto power on appointments. What if Chief Justice says don't appoint him? You are giving a veto power to the Chief Justice, right? Am I right? And that's what he said. Such a power, without any checks and balances, would defeat the careful interinstitutional equilibrium that had been envisaged for the appointment process. It is an equilibrium, both are equal. And today, are they equal? It is the judiciary which is appointing, right? And the government or the president has absolutely no role except signature. And that equilibrium has been disturbed. That's what I would like to point out here. The equilibrium that Ambedkar wanted to present in the Constitution, which is also present in the Constitution, is possibly missing today, right? That had been envisaged for the appointment process. Besides, an unchecked power had large potential for abuse, given that the Chief Justice of India, despite being a person, right? Please, I hope Ajit is following what I'm saying, right? This is very important for you. Giving that the Chief Justice of India, despite being a person of high integrity, could only be expected to suffer from infirmities and biases as any mortal would. You got the point? It is not that they did not discuss, right? You expect the Chief Justice of India to be of a person of high integrity, but still he is also a human being. And if that check is to be there, the check has to be in the executive, not in the judiciary. I hope you understand what I am saying. When Justice Dinakaran was elevated from the Karnataka High Court to the Supreme Court, right, based on whatever charges they level, I don't want to get into the details of the removal process, right? The president could have stopped it. He didn't. Right? President could have withheld that order or cancelled that order. He didn't. Right? Why is it? Then only the court becomes all powerful. Then if the court becomes all powerful, the faith that we hold in the judiciary starts crumbling. I want you to carefully think about this. So Ambedkar also spoke about the mortal image of each and every human being. Right? Everyone is like this. As a result, the amendment seeking concurrence of the Chief Justice of India, both for the Supreme Court appointments and High Court appointments, were negatived. And today what is happening? Consultation is concurrence. This is what the court said. The opposite of whatever was written, whatever was said, it is not that they did not consider concurrence, but they wanted to put a check on the power of the Chief Justice. They want to put a check on the power of the executive so that the equilibrium is maintained, and they rejected concurrence and selected only action, right? And that has been now violated from 1993, from the first Skora judgment, right? Consultation is nothing but concurrence of the court. A collegium be 3 earlier, now it is 5, right? So in my opinion, that is totally violative of the constitutional morality, which the framers of the constitution wanted to present in the process of appointment of judges. If the court is speaking about constitutional morality today, let them address this situation. Let them address this issue, right? What was discussed and what was accepted, right? Okay. Then once again, I have to refer to K. Munshi and the appointment of judges. He said, the safeguards are there. Largely, however, it would depend on how the judiciary works, what the spirit of the legislature is, and what the spirit of the executive works. That is a matter which principally lies with those working the constitution, right? So I would like to just sum it up by saying the framers of the Indian constitution very neatly thought about, discussed, analyzed, and presented a constitution in which the independence of the judiciary will be maintained. I'll just give you two of things. What is meant by this independence, right? In my opinion, I'm not referring to any definition. This is my own, right? You may find fault with my observation, but I would like you to challenge, right? Then only I can keep on expanding whatever I have written or whatever I am saying, right? So in my opinion, independence of judiciary can be defined as a strong thread that runs through the process of appointment. Please carefully listen to me. That runs through the process of appointment, right? I mentioned merit as a basis, right? During the tenure, second stage, one is appointment. Second one is during the tenure of the judges. That is conditions to ensure independence of the judges. What is it? Fixed tenure, right? Now the judges of the Supreme Court can retire at the age of 65, while the High Court they retire at the age of 62. It's a fixed tenure. You know very well when you are appointed on the reaching of your appropriate age, you will be out of the court, right? So fixed tenure, salary and other service conditions that cannot be reduced during the tenure of the judges. During the tenure of judges, you cannot reduce their salary, right? Except according to Article 360, if the financial emergency is invoked, right? Please read 360 in that context, right? Cannot be reduced during the tenure. and the removal based on two specific grounds, only two specific grounds, right? That is given in the Constitution. Article 124 is amply clear about it. What is that? What are the two grounds? Can anyone say?
Proved misbehavior and incapacity.
Incapacity, yes, proved misbehavior and incapacity. We are now in the 73rd of Republic, year of Republic. We are not able to understand what this proved misbehavior would be. When you have elevated the judges to the highest position possible, greater the authority, higher should be the levels of morality or morals. Do you agree with me? Right? समझदार के लिए इशारा ही काफी है. That is the level of morality that we are looking at. Not when 14 charges are proved, the judge is still, continuing to say, no, I have not done any mistake, so I'll continue. Or Soumitra Sen saying, I will not resign, come what may. Right? And the other judge saying that I have submitted the resignation. So will it wash off their sins they have committed? That's the question. And therefore, these things must be kept in mind. So 3 stages: appointment, whom to choose. During the tenure, the second phase. And the third phase is very, very important. Right? Post-retirement status as well. Now, if you have the text before you, will you please read Article 124, Clause 7? Any one of you?
Sir, I will do that.
Yeah, anyone? Huh?
I will read it out, sir, for you.
Yeah, please.
No person who has held office as a judge of the Supreme Court shall plead or act in any court
please,
or before any authority
Ajit.
within the territory of India.
Ajit, go slow. They have to follow,
Okay,
and
sir.
I have to say something.
Okay, I will be slow this time. No person who has held office as a judge of the Supreme Court.
Yeah, pause for a while. Is it very clear? This applies only to the Supreme Court judges, not to the High Court judges. I should pause. A person who held the office as the judge of the Supreme Court, which means it will not apply to the judges of the High Court, including the Chief Justice of the High Court. Why? I'll come to that. They retire at the age of 65. They can go and practice in any other court. Wherever they did not work as judges, they can go and practice in other high courts, and they can also appear in the Supreme Court. There is no bar. Right? Now read the rest of it.
No person who has held office as a judge of the Supreme Court shall plead or act. Or act.
Yeah.
In any court or before any authority within the territory of India.
Right. Any court includes Supreme Court as well. That is not true with reference to High Court judges. I told you that they can practice in other High Courts wherever they did not work as the additional judge or even as a judge. Additional judge is okay as a permanent judge. They can appear in the Supreme Court. But once you become judge of the Supreme Court, you cannot act or plead in any court. Right? Or there is something else. What is it? The last part of it? Ajit?
What, sir? I didn't get, sir, what you said.
No. Before any
authority, sir. Before any authority.
Before any authority. So, court is not the only authority. Right? If you have to act, I'll just put it this way. You cannot take any position with the government, statutory or otherwise, because you will be acting under that authority. Because the appointing authority will be the president. Right? So therefore, the post-retirement status is very, very clear in 124(7). But what is happening is entirely different. Right? Whereas High Court judges can practice, the Supreme Court judges cannot practice, nor can take up any of the positions. Right? I have a very strong view, like some of my colleagues in Law School Bangalore, Professor Devidas, right? That even the appointment of the Chairman National Human Rights Commission, right, will be attracting this provision, in my opinion. I may be wrong, but that is the way I look at it, because I'm interested in bringing the right-minded people to the judicial system. That's my objective. And therefore, I would like to look at it like this. Okay. Now, as far as the constitutional provisions on the appointment of judges, right, and to get the independence of the judges and judiciary, there are provisions like 124, 4 and 5, and Article 125, 129, 140, 141, 142, 144, and 145. Right? I will not elaborate on this. That I think every one of you know about it. And similarly for the high courts, 217, 20, 220, 221, 226, and 227, which speaks about the power. Right? One thing important which I would like to flag here, before I get into other part of history, is it possible for the parliament to make a law regulating the appointment of judges? I would like to take your views. I once again repeat the question. Is it possible for the parliament or the state legislature, for that matter, because High Court is within the state, isn't it? Is it possible for the parliament or the state legislature to make a law regulating the appointment of judges, either the High Court or to the Supreme? What's your view? I want a couple of comments.
Sir, they already did that with the NJAC.
No, that judgment comes after the law was made.
So, may I, sir?
Yeah, please go ahead.
So, as far as lawmaking is concerned, lawmaking is concerned, it's completely hand over to the parliament. So, I believe, sir, personally, I believe that they can create a law. They can come up with law.
Very good. Is there anyone who would like to hold a different opinion altogether? Otherwise, as teachers, we cannot simply say the court said it and therefore it is valid. We should have thinking, ability lies, right? And we have to prompt our students to think on those lines. Yes, madam. Somebody is saying something. You have to unmute yourselves. I think I see law 9. You have to unmute yourself, madam.
Rashi ma'am, you are unmuted.
Will you please tell her, is she trying to say something or she's
No, sir. I think there's some other thing happening. We'll carry on.
Okay. Right. So I have raised this question. Is it possible for the legislature, parliament, or the state legislature to make a law? And the court declared that law unconstitutional. That's what the first opinion given by Arthej was. The contrary view was expressed by Ajit Singh. Right? I have done some work, and therefore with a little bit of confidence, I can tell this.
I think, sir, to be precise, state government will create a law for the High Court and the Parliament will come up for the Supreme Court.
That is why I asked both the question. Legislature, right? Can it make any law regulating the appointment of judges to the High Court or the Supreme Court? Right? I have gone through. This is not the time. I cannot go on explaining each and every article. I have gone through the entire constitution relating to the judiciary in general. Right? Please carefully listen to me. I have gone through all the articles relating to the judiciary in general and the entries relating to the judges appointment or whatever it is in the 7th schedule to the constitution. There are about 23 articles in the constitution which provides the power to the parliament to make law with reference to judiciary, right? For example, salary. increasing the number, service conditions. They can make certain laws, but not even a single provision out of the 23 provisions that I referred to in favor of the parliament and one in favor of the state legislature provides the power to make a law or the appointment of judges.
Just give me 2 minutes. 2 minutes. Let's go, darling.
Professor Ranveer Singh,
Yes, sir. He is joining.
He's joining.
Yes, sir. We'll
Yeah.
just ask him to mute once.
इसको ऑन करो भाई तू यहीं रहना कैमरा कैमरा
Sir, if the technical team can just mute Ranveer, sir.
Professor Ranveer Singh, you can still say on.
Yes, sir.
Okay, I think he has been.
Yes, sir. We welcome
Right.
Dr. Ranveer Singh, and he is here for the valedictory session and also to listen to you, sir, in the meanwhile, till we reach the end of this session.
Okay. No, I can go on for 5 hours. Are you willing to?
Yes, sir. We can
It's
go
the
on till
topic
3.
of my. Right. So please carefully listen to me. I have gone through, not gone through number of articles, but identified 23 articles which provides the power to the parliament and the state legislature to make law on every aspect of judiciary, but not on appointment of judges. Right? What does it mean? Let me use the judicial tool itself, a judicial tool of interpretation, which very clearly says whatever is specifically mentioned, right, excludes the contrary. Am I right? Expressio unis, yes, exclusio alteris. The expression of one thing is the exclusion of the other. So there are 23 articles which include something, and all of them collectively excludes the power to make a law with reference to the appointment of judges. Right? I don't know whether it is a valid argument. In my opinion, unless and otherwise you are authorized to do something under the Constitution, you cannot infer something and do whatever you want to do. Right? What does it mean? The power to appoint the judges of the superior courts, the High Court and the Supreme Court, is to be vested only with the executive body, the president. He is appointing authority. He has the power to appoint. That is what the Constitution provides for. Right? But when that has been diluted, saying that the Council of Ministers will suggest and he will only sign, that ability of controlling even the judiciary or any other branch comes to an end. Right? I don't know whether this lady is trying to say something, 09, law 09. I am able to see her trying to talk or ask something. Can anyone find out? What is her name?
Sir. I'll just look into it, sir.
Yeah. She's trying to say something. I don't know. Okay. So please keep this in mind. 23 articles of the Constitution, not even one is about the process of appointment of judges or choosing the judges or recommending anyone to the president or the minister, right? By anybody. That is not at all even mentioned. And how can you say that law can be made? And therefore, my first observation is the law introduced and made by the parliament, ab initio is void. Right? They cannot think of introducing a law. Right? So whether the court has done a good job, yes, the court has done to that extent a job. But having done a good job, it has also done another job, bad job, saying that the power is vested with them. And that is a place where the question comes into picture. Right? Okay. Now there are other cases on expressio unis. I will not get into it. There are 4 phases of appointment of judges that you have to keep in mind. Next few minutes, let me quickly sum up the entire process. Between 1950 to 1973, Second phase, this is not given in any book. This is my own classification. And I'll try to justify why I have classified like this, right? Second phase is between 1973 and 1975, just a period of 2 years. 1976 to 2014, right? And 2014 to present. Now, what is the significance from 1950 to 73? For the first time, the senior most judge of the Supreme Court was not appointed as the Chief Justice of India. 4 senior most judges were superseded, and the 5th one was appointed as the Chief Justice. Who was it? Who was the judge?
Justice A.N. Ray.
A.N. Ray, Justice A.N. Ray. You are right, absolutely right. Justice A.N. Ray was appointed, superseding 4 of his senior colleagues. And all the 4 had to resign and go. This is the consequence. Now you look at it, if all the 4 members who resigned and left were of higher moral quality, and it is a loss to the court itself, not to the people of India. Or you can say it's a loss to the court, and also it is a loss to the people of India. Because it is we, the people of India, we have adopted and given this constitution to ourselves. And therefore, such a damage cannot be caused. Right? So therefore, the first deviation, major deviation to 1973. So I like to classify that branch 73 to 75. It was during that emergency period, right? The second emergency was imposed in 75, and the second supersession also took place. This time, one senior most judge was superseded by a junior judge. Can you also suggest who was it?
Justice Khanna
Was superseded by H.R. Khanna, superseded by M.H. Beg.
M.H. Beg, yes, sir.
Right? Now, if you look at the H.R. Khanna resigned and left the court. Now, if you just look back to Khanna versus State of 1967 Supreme Court, these judges were involved in one form or another to write the opinion. Right? And find out whether they were the part of that or not. And therefore, why this supersession took place. This is the second phase. Third phase is from 1976 to 2014. That was the time what was considered an internal affair of the judiciary, right, came to limelight, that the president is always bound by the recommendation given by the Council of Ministers. Right? Samsher Singh versus State of Punjab, 1974, judgment of the Supreme Court. A 7-judge bench, unanimous opinion that the president cannot act on his own. He is always to be guided by the Council of Ministers. I think that is the time we lost the entire independence of the court, right? To whatever it is, to the political bosses, which Dr. Ambedkar and Prime Minister Nehru wanted to avoid. And I hope I read out what Nehru said, isn't it? Who can stand tall, right, against any other authority, right? And can you think that the judiciary can stand tall at all? Or can it stand at all? Right? Can it stand tall at all? Or can it stand at all? These are the 2 questions which we need to ask ourselves. Because we are not critiquing somebody, or we are not criticizing anybody, but we are trying to find fault, because this is our constitution and we need to look at it. And then comes the last phase, 2014 to present. Right? I want to give some sort of exercise to all of you, not for any supervision, right? But out of curiosity, having listened to me, but whatever I'm saying is right or wrong, I would appreciate you please go to the website of Ministry of Law and Justice, and there is a Department of Justice. There are 3 departments. There is a Department of Justice, and in the Department of Justice, there are 2 pieces available to you, 2 of them. First one is Memorandum of Procedure of Appointment of Supreme Court Judges. When I was trying to explain to you, the Parliament cannot make any law for the appointment process of any judge of the High Court or the Supreme Court, can a memorandum stand valid? Whoever has made it, right? And certainly not the political bosses making the memorandum, right? So this Memorandum of Procedure of Appointment of Supreme Court Judges under Article 124 is one. And then the second one, which you will see in that list, is Memorandum of Procedure of Appointment of Court Judges, right? Please, I have done my homework, right? I can show you documents. I have done my homework, but my doing homework has nothing to do with your association. Keep the constitution provisions as they are on one side and go through the Memorandum of Appointment of Supreme Court Judges and High Court Judges and find out the number of contradictions present in that. And today we are passing the procedure, and then it is the judges appointing themselves. It has, every system has pluses and minuses, right? But when the judges appoint themselves, can they be independent? Can they be impartial? Right? And that is a place where I come to the practice that is going around, which is written anywhere, right? For example, there is a vacancy from Tamil Nadu, right? Here is the 34 judges of the court. Is the vacancy of any particular state. What happens if the number of states in the country is much higher than 34? Right? One state will go percentage. Then comes a particular caste, minority, sex-based, right? I think recently you must have seen that a lady judge was appointed, who is a very close friend of mine and my wife. My wife and her, they practice, right? I am not anything against, but that it is projected, right? That she is going to be the second in India based on sex. Now, after 73 years, this is the question that I would like to leave in. After 73 years, we have not found out a procedure where a judge, a citizen who is a citizen of this country, who can stand tall, stand above all these parochial interests, caste, race, religion, minority, status, this, that, and deliver judgments based on the constitution and the laws. And the more you bring some other parochial interest, then I think we are diluting the authority of the court by, and thereby diluting its competence as well, right? I don't know whether you agree with me or not. I don't want you to agree with whatever I'm saying, but I'm putting all these questions so that you can start thinking on those lines and collect some information, write some articles, and if you don't tell, who else will tell, right? And that is with this intention I am trying to explain to you that this is not correct, right? And therefore, the referred to, right, the new convention that they have created in the first Skora judgment, right, of 1994, right? The judges said they spoke almost around 10 pages of reported judgment on constitutional conventions, right, on the appointment of judges. What is the nature of constitutional conventions? They said the constitution cannot prescribe everything. Certain conventions need to develop. I hope we are all students of legal methods, and we have all seen there is only one difference between custom and the law. No custom can exist if it is against any written law. Am I right? No custom can be valid as against a written provision of any law. constitutional conventions are also like that. A convention is only to fill the vacuum, fill the gap. Constitutional convention, the oil, right, is the oil for the joints to function effectively, right, for the pistons to run effectively. And it cannot go against, instead of oil, you put the sand. Will the piston work? The moment you put it, it will stop. So therefore, even constitutional conventions on which the Supreme Court spent around 10 pages in saying what constitutional convention is, right? At the very same judgment, they have violated the written provisions of the Constitution to give effect to the constitutional conventions, right? I am talking about the appointment of the judges, and that's what I am trying to say, right? So therefore, we need to introspect these 4 stages. That's what I told you. I have got all the references, the Sankalchand case of 77, SP Gupta of 1980, right? Kumar Padma Prasad of 1992, State of Bihar versus Bal Mukund Chand 2000, and Subhesh Sharma versus Union of India 1991, right? And the Skora judgment of 94, presidential reference to 1999, and the present Skora 3 of 2014. I have given you all these developments, and I don't think I have to guide you and take you, because you're all teachers, right? And take all these things and find out whether the constitutional amendment, right, 121st Amendment Bill, which culminated in the form of an amendment for the appointment of judges, as well as the 99th Amendment, signed by the President. See, 2 authorities are involved in that. The President, who is the appointing authority, also signs the bill. And he is committing suicide by saying that the Parliament will decide. Instead of him exercising the power, he is authorizing somebody else to exercise the power, right? And then if you carefully look at it, the Constitution, there is the Prime Minister, leader of opposition, and the consultation of the Chief Minister. Now I think we are all working against what the Constitution wanted to prevent the Constitution from going backwards, right? So therefore, I always appreciated the court by sitting down and that as unconstitutional. That is one part of it. But the second part of it, which I do not agree with the court, is that it cannot appoint its own members. I hope you understand what I'm trying to say, right? I don't know whether there is any other country in the world which can appoint its own judges. They say South African constitution is almost akin to it. I don't think to have a good example of bad constitutions. South Africa may be good in many respects. If in this respect it is bad, I think we need to call it as a bad constitution. We have to articulate and call it a spade, right? Now sit with say something, right? So then I put the matter to the bench, right? And then a 5-judge bench. Even the appointment of a 3-judge bench into the Skora judgment, in my opinion, is unconstitutional. Please look into Article 145(3). I once again request Ajit to read this 145 clause 3, because if I say unconstitutional, I must give a reason, isn't it? It's not my wish. 145 clause 3, please, if you can.
Yes, sir. Just a second.
Sir, I'll read it.
Yes, sir. It says
Okay.
Yeah, please.
The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution, or
Yeah, pass it. Any substantial question of law or interpretation of this constitution, isn't it? Yeah.
or for the purpose of hearing any reference under Article 143 shall be 5.
So is it a constitutional mandate? Minimum 5 judges must be present. And is it a constitutional interpretation? Who has the power to appoint or not? If it is involved, how do you think a 3-judge bench can decide this? Right? Please look into it. Right? And then the judges themselves looked at it and said, no, 3 judges cannot decide, and a 5-judge bench is to be constituted. And then the 5-judge bench refused to plea for the stay on the notification of NJAC, and then what happened is entirely different. As a fallout of the 3rd SCORA judgment, there was also a notice that people who have different views on the appointment of judges can submit it to the Supreme Court. Right? So I was also waiting for an opportunity. So I wrote a brief, right, telling that this appointment process decided by the court is wrong for the following reasons. I have given all the reasons, and if you are really interested, I will please write a mail to me. I will send you that copy, right? Because there are different processes of consultation. The consultation for appointment of judges of the Supreme Court is different. Consultative process for the appointment of judges in the High Court is different. Consultative process for the appointment of Chief Justice is different. And consultative process for the appointment of ad hoc judges is also different. So there are 6 such provisions where consultation is being used. And the Supreme Court did not refer to any one of them, except Article 124 or 217. Right? So therefore, I have given certain references, and you cannot put everything under one banner and say that consultation is concurrence, and therefore the concurrence of the Chief Justice and the Collegium is final, right? And that approach must be dispensed with. And then finally, I also made a statement which Jeremy Bentham mentioned, right, which is very, very interesting for all of us. Lawyers are the only persons in whom ignorance of law is not punished. Right? I hope all of you know the ignorance of law is no excuse. That's a maxim. But Jeremy Bentham very beautifully put it, lawyers are the only persons in whom ignorance of law is not punished. Right? And when I don't want to say that the judges are also ignorant, sometimes they may miss the written provisions of the Constitution. It is our duty to highlight and tell the judiciary that this approach is wrong for valid constitutional provisions, and tell them to correct it. I think they will correct themselves, right? And therefore, the appointment of judges in whatever form it is taking place today from 1993 and right from 1950 itself, I would say that they are not based on the constitutional provisions at all. Today, it has been mortgaged to the Ministry of Law and Justice, right? And thereby, the president, who has the power to do it, has become only a signing authority. And if it is so, if that is the right way of doing it, why not we say that law minister will appoint? What difference will it make? Appointment order is the appointment order. If any change is to be required in the Constitution, we make it, right? Let us do it. That's not an issue. But as long as these provisions continue to remain in the Constitution, these aspects need to be looked at it. I have one question, WS, I don't know who it is. The Supreme Court in the second judge's case, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India, is just only seniority we can consider for appointment, right? Please go through Article 124, right? If what you say is right, what were you doing when A.N. Ray was appointed? And what were you doing when M.H. Beg was appointed? Where were you? Right? So that's why I know with all the facts, when you sit and discuss, you raise questions, counter questions, try to find solutions. Our intention is not to criticize somebody. but critique the provisions of the Constitution, critique the provisions of law, and therefore sometimes many of the judges, I have been interacting with many judges, and the process needs a thorough revision, a public debate, a discourse through which something better will be born. And I have given my own proposal to the Supreme Court. And if you want to know about that, please email it to me, or I will mail it to your coordinator, who can distribute or disseminate that information to others. So I will not take much of your time. Professor Ranveer Singh is waiting, and it is 3:30. To be very frank with you, I'm yet to start. Whatever I have given is only the foundation for you to think about it, make some sort of appreciation based on the written provisions, rather than simply reading the judgment and saying yes to it, right? Then I think you become a good critic, and then you become what you call it as a person to safeguard the democracy in this country and safeguard. Now, the beauty of that, I'm sorry, I forgot one more thing. I told you about separation of powers on the other extreme. What is separation of powers? Once again, the powers between the executive, legislative, and judicial branches, right? The Supreme Court in a catina of cases has emphasized, and starting from Keshwan Bharati, 4 judges of the Supreme Court also mentioned separation of powers is a basic feature of the Constitution. Now, don't you think that when other branches interfere in the appointment of judges is also violative of that rule of law, is also violative of that constitutional morality? Right? These are the questions. So therefore, separation of powers can come to the rescue to maintain the status of each and every branch against the onslaught of other 2 branches. If this equilibrium, which Dr. Ambedkar mentioned, is disturbed, then I think the Constitution is likely to suffer in the years to come. I'll stop here. Thank you very much for your patient hearing.
Sorry, sir, to interrupt you. I have just one query. Just a short while ago, we thought that when the judges are elevated to the Supreme Court, why not put their remarkable judgments in the public domain so that everyone comes to know why they are being elevated to the Supreme Court? And another aspect of that is what's happening in Karnataka High Court just now relating to hijab, because the public hearings. Do you think all these things can bring some sort of transparency when it comes to the appointment of judges?
There are certain things which you must keep them to closer to your chest. Don't have to disclose everything, right? In the name of transparency, let us not even bring down the status and image of the court, right? I am telling this because I have been following all these things. You nominate X as the judge, right? All other fellow lawyers will join together and write petitions against him, right? You will make the process much more difficult by being transparent.
Okay.
I'm not joking. Chief Justice of India at some point of time very clearly mentioned this to the press, that we cannot consider any name, because the moment we consider some name, we get petitions that he was like this, he has taken, he has got 2 wives, he has got 4 buildings, he has got this, he has got that.
No, just his remarkable judgments.
No, that I understand. That's a good decision. But who will assess it? Do you think that the Chief Justice of India will sit and read all of them? Who will assess? What is the purpose of saying that? I do understand on the other extreme. If you remember, one of the, I think the Attorney General made a remark that one judge who has not even written 5 judgments in the Supreme Court is serving in the National Human Rights Commission, right? I hope you know, these are all the comments. So, then you have to identify who has appointed them. Not only that man, anybody. So therefore, I would not agree with you on this point that the judgment is to be. Who will verify? then you have to constitute a committee, right? It is not this. I don't think any Chief Justice will have the time to sit and read everything and then decide who is the best judge among them, right? So therefore, that judgment writing is always the function of the judge. They may commit certain mistakes. There is nothing wrong in it. Committing mistakes in the judgment writing is always correct. And that is why the appeal procedure is given, revision is given, everything is given to the court so that at the appropriate level it could be overruled. So I don't think it may be a good judgment on your part, but from my side I look at the consequence, right?
Practically.
You have to suggest where the medicine does not become worse than the disease. The medicine that you propose should not become worse than the disease. Right? That's the concern. But it's a good question and good response that you have had in your mind about reading the judgments.
Thank you so much, sir. In fact, this has been a very, very informative, engaging, and thought-provoking session. And on behalf of Faculty of Law, SRM University, and all the participants, I express my deep gratitude to you for taking out so much time. And soon we are going to start with the valedictory also. I think, Hartej, sir, can we give just 2 minutes break? If sir wants.
Yes.
No, you can continue.
Okay.
When Professor Ranveer Singh speaks, I'll have my lunch.
Okay.
That's not an issue.
So you are asking him to prolong his speech then.
No.
I will speak for, in that case, I'll speak for 5 minutes.
No, even I have spoken.
You can
enough.
have your lunch.
Thank you so much. Over to you, Hartej.
VC sir be joining?
Yeah, there is
He is busy in another meeting.
Okay.
Okay. There is a comment
Sir, the question is, why not law universities entrust with the duty of analyzing the judgments before the appointment of judges?
Right? The moment you propose, the judges will say, who are you?
Yes.
What competence you have? Right? So, this are all coming with loads of information we need to analyze very clearly. That's why even if you have a symposium for about a week, I think we have tons of material to analyze, discuss, and come to a conclusion. It's not that easy. Right? Now look at the American practice. The judges are appointed by the president based on party affiliations.
Yeah.
Right? I hope before the previous president, Trump, he had only 1 week to go. He appointed a judge who was a hardcore Republican. They knew that, but he expected that the judgment will turn in his favor. It happened in Bush case. But in Trump's case, she also joined the majority, which means as far as the appointment is concerned, you can be anyone. But the moment you are appointed as a judge, you have to give up all your affiliations, political, economic, or otherwise. You have to give up all your affiliations and stand tall. Then only the judiciary is able to survive.
Thank you, sir. With that, I would like to move on to the valedictory session. With your permission, sir, and with Ranveer Singh sir's permission.
I'm ready. Let Vijay have his lunch.
No. You can start. Not an issue. I'll speak for another 5-10 minutes and then I'll go for lunch.
But then you have to speak again.
Yeah, how long?
There are a couple of minutes, but before that, Professor Ranveer Singh sir has to speak, so you can get your time for lunch.
Yeah. Let it
So
I'll
wait till you finish your lunch.
No, you can continue. Please continue. Don't wait for this.
No, I'm saying
I'm quite used to this.
The moment you come after finishing your lunch, I'll stop.
Then I will not come for 1 hour.
Okay, no problem. I'll carry on.
Yeah, please start.
I would extend a very warm welcome to all for the valedictory session of the 5-day faculty development program on contemporary issues and changing facets of law conducted by SRM University Online. I would like to welcome our esteemed and learned speakers and guests. Honorable Chief Guest, Professor Dr. Ranbir Singh, who is the former and founder Vice-Chancellor of National Law University, Delhi. Our guest of honor, Professor Dr. Vijay Kumar, who has just enlightened us with great words. I would also like to welcome our Registrar and Dean Academics, Professor Dr. Samuel Raj. I welcome our officiating Dean and Head of Department, Professor Dr. Komal Odich, along with other distinguished panelists and faculty members and participants. Over the past 5 days, we have been greatly enriched with the pearls of wisdom that our speakers have shared with us. We have received an overwhelming response from the participants of the 5-day FDP. And we have received positive feedback as well from the participants after every session. We have been receiving calls that the sessions have been well received and they're complimenting us. So we are thankful to the participants as well for their participation during these sessions. The total number of participants in the sessions were 81. They included PhD scholars, academicians. They were assistant professors, associate professors, and even professors. We received participation from all across the country. There were registrations from Telangana, Tamil Nadu, Bihar, Rajasthan, Delhi, as well as Punjab. All the sessions were very, very informative. They discussed the areas that are of great benefit to the participants as the topics were of extreme contemporary importance. And the participants have gained fundamental knowledge on the contemporary issues, which will further enable their development as researchers or faculty members. Before I invite our chief guest and guest of honor, I would like to request our Registrar and Dean Academics, Professor Dr. Samuel Raj, to say a few words regarding the event.
Thank you. Thank you so much, Tej. Can you hear me?
Yes, sir.
Yeah.
Thank you.
Samuel, keep it few words.
Sir, I'm so glad to see Professor Dr. Ranbir Singh. I would like to say that, he, in my opinion, so he is the best, professor in law and a well-known and a renowned professor. I always look at him with a lot of respect. I have the privilege to, talk to him and meet him in the past 3 years, even before the COVID. And during the COVID, we could, I could see him through the, see him in the virtual meetings. And whenever I see him, I always get a lot of, encouragement, for the knowledge that he has. And also, the way he is well respected in the law field. Okay, I know that all of you would agree with me. He is the top person, and I'm so glad, Professor Dr. Ranbir Singh has agreed to be here. I am also just waiting like you to listen to him. In front of him, I'm just, nobody to talk. But, like you, I'm also just waiting. And I'm so glad to know that the Faculty of Law, could arrange this FDP. And I'm so glad to see that, the faculty from other universities could join this event so that they get the best out of this event. I know that all the speakers, Dr. Komal was discussing with me as well as VC sir about the speakers before arranging this FDP. And I know that all the speakers are the topmost people in the field of law. And I know that, our faculty members are really privileged. You are very much privileged and blessed that, you are having Professor Ranbir Singh with us. And he has been here in the campus also many times, and then he will continue to visit us and, bless us. And also, I am thankful to Professor Ranbir Singh, sir, that he is part of our ethical committee. University has the ethical committee. So he is part of our ethical committee where, Dr. V.M. Katoj, our former Director General of ICMR, is also there in the same committee. And Professor Ranbir Singh is a great blessing for us. And then he is part of our selection committees and he supports. That is the best part. He is a mentor for so many institutions. He himself is an institution builder. And in which I don't want to talk, take too much of time. I, wish the department, that you have done a good job, and especially Dr. Komal, for organizing such a great event and getting all these people. It's very difficult to get all these people at one place for one event. I don't know how you could manage that one. So that shows the organization skills, and also the support that you receive from the department. I really appreciate all the faculty members, and also the faculty members, those who are attending from other universities. So thank you so much, sir, and we are just waiting to listen to you, sir, and vote to the organizers. And thank you so much for all the participants who are attending this one. Over to Dr. Komal.
Yes, before I invite Professor Dr. Ranbir Singh, sir, I would just like to introduce him. Professor Dr. Ranbir Singh is the founder Vice-Chancellor of National Law University, Delhi. He was also the founder Vice-Chancellor of Nalsar University of Law. Yes, sir.
Very briefly, very
Yes, sir. Yes, sir. Sir's contribution in the field of legal education is well known. He's a well-renowned name. He's a well-renowned academician. He has published various journals and he's been awarded various awards as well. He has represented India on various international forums as well. In fact, the British Council has recognized him as one of the 12 talented, creative, and generous spirits who are making an effort personally and through their institution to ensure the engagement with the United Kingdom. And Sir has received various Lifetime Achievement Awards, Excellence Awards. He has served as a professor at NLS Bangalore, and we are very grateful to have him because, as Registrar Sir also stated, that he has a constant connect with SRM University's Law Department, and he's always there to guide us whenever we need him. Sir, with that, over to you.
Thank you, Hartej. Thank you, Komal, the Dean of the Faculty of Law at SRM, and Dr. Samuel, the Registrar, all faculty members. Me and Jaswar are both at Rohtak to attend a selection committee meeting, and we just got free. He's talking to some other meeting, and I'm in another room talking to you. And I thought the program would be at 3 o'clock, so I got panicky that I'm late. But fortunately, I saw the program is at 3:30, and I'm lucky that I could listen to my dear friend and brother Vijay Kumar for a brief period. Now, the topic of the day, when you come to the valedictory, one thing is that everybody is tired of everybody. By the time somebody has to speak on valedictory, and speaking on a valedictory is a very, very difficult job. And people somewhere curse you, why don't you finish, fellow? Taking so long. No? So, first I will come to contemporary issues. I'm sure you must have discussed all contemporary issues. 5 days is a long time to discuss all those issues which we face in the present times. But I will be more on theoretical background, and when I take a synoptic view, and when I take a systemic view and a symptomatic view, I look at the people, and when I look at the people and try to find out whether we have kept our promises which we promised to the people of India 75 years back. What is your answer? If we have to ask you this big issue that after 75 years of India's independence, what we promised in the people, have we fulfilled those promises? I'm not saying that we have not achieved anything, we have achieved enough, but we have a long way to go, because the 3 things which we promised was justice, social, economic, and political. So these are very, very, very value-loaded words, and we have to achieve a lot in these fields. And when we have a critical angle at these what we promised, we find India's revolution of August 15, 1947 has still remained unaccomplished. There are many things that are still to accomplish now. The problem is we are still trying to figure out to meet the challenge of these issues which we are facing, how to redesign the institutions. We are still grappling with delay in cases. The kind of cases which are pending in the lower courts, the High Court, the Supreme Court, we have been struggling for a long time. And the saddest part is that the load is increasing. It's not that the load is decreasing, and that creates all kinds of problems for the common man, and it antithesis to justice. So the question is, how do we redesign our institutions, sustain the operators, and now we need to have a climate of positive climate where we can look at these issues where people in the country, the ordinary people, are convinced that we are doing something. So we need to have a new culture of administrative law, a new culture of parliamentary process, and we need to have a socially sensitive judicial process so that justice for millions is actualized. Now, still, you see, sometimes when people talk of the delay in cases and the pending cases, I still say that I'm not worried that why so many cases are pending. And people ask me, what do you mean by this? I say you should be lucky that people are still coming to the courts. And the day people stop coming to the courts and they think justice is not possible, that would be a very worrying day for everybody. So that means the people have still faith in the courts. The common man or woman have still faith in the courts that they can still get justice, maybe delayed, but justice is possible. So the big agenda before the nation is to solve these issues are how to evolve a system which is responsive, accountable, not apathetic to people's demands, justice. How to have a new constitutional order where the operators are no more untroubled by the miseries of the masses. So if you are untroubled by the miseries of the masses, that includes not only judges, that includes also you and me. That is why in all law schools, there is a provision to go for clinical legal education and legal aid. And whenever I go for lectures to the orientation, in fact, for the orientation in any law school, I always say the mandate of any law school is to produce a generation of lawyers, those who are technically sound, professionally competent, and more important for me is socially relevant. If we don't produce lawyers those who are socially relevant, then we have not done our job well. So how to assure the man in the street that he is not alienated against the law, since the baffled with its buck, Himalayan heap of legislation, so much of law we have, that we are overloaded with law, but at the same time, we still need to evolve a jurisprudence which is civilized jurisprudence. And we are all eagerly waiting for that. So the real concern is a painful absence of a theory of human justice. The Constitution inscribes justice as the first promise of republic, which means that the state power will execute the pledge of justice in favor of millions who are the republic. Social justice is people justice, where the tyranny of power is transformed into the democracy of social good. So the question is how to inaugurate a human tomorrow, how to have authentic social justice against counterfeit justice. While traveling to Rohtak from Delhi, I was looking at the Constitution, and I suddenly looked at Article 1, where you say India, that is Bharat. So I thought, do we have two Indias? One is India, which is powerful, rich, wealthy, affluent. Another is Bharat, where we, the people of India, and we, the other people of India, mean the people, those who are at a disadvantage, maybe Harijans, maybe Dalits, maybe disadvantaged people, or we have, what is the India's actual story? We have two Indias, or we have many Indias in one India? And I prepared a list for you. You will be surprised to know that in these 75 years, India has not one story, but has many, many stories within India itself. And those stories are that we created, let me share with you, we created rich India, poor India, urban India, rural India, India which lives in high-rise buildings, India in slums, highly educated India, illiterate India, high-tech India, highly non-skilled India, India which discards tons of foods in marriages. You all attend marriage in those banquet halls, and how much food we did, how discard and waste, everybody knows it. And the other India, if you ever try to look at when you move out of that pandal, how many people are taking that discarded food from those boxes and packets, and they survive on that. So another India survives on discarded food. There's one India which works in the day, another India which works at night. You know those call centers which work at night. One India travels in big cars, another India still traveling in bullock carts. India which have best of healthcare, and another India there is no healthcare. We saw it during COVID as to what happened in the smaller towns, and especially in the villages there was no facility at all, and how even in the best of places how the healthcare suffered. Highly empowered India and totally disempowered India. The widening gap between the rich and the poor, where according to Mr. Arjun Singh Gupta's report on poverty, nearly 1,000 million people live on just ₹20 a day in this country. Should be a warning to everybody, all of us, dealing with law, maybe lawyers, judges, or students involved in good governance. The issues are many, as I discussed with you, and it will not be possible to deal with all those issues in such a short time. And the challenge is huge. The solution has to be found today, tomorrow may be too late. And we have to reach the unreached, we have to help the unhelped, we have to somewhere care for the uncared, attend the unattended. We, as you remember, Jawaharlal Nehru, the first Prime Minister of India, used to keep on his table the lines of Robert Frost, saying, "Woods are lovely, dark and deep. We have miles to go before we sleep. We have miles to go before we sleep." So there is a long way to go. So to very, very brief, the issues are sustainability and development. I will not deal in detail. You must have done it. The disparity between rich and poor, the divide, and you saw that divide during the pandemic, and when suddenly we saw that tomorrow is different, and everybody has to shift to online teaching, and as if everybody is expert, and where nobody was expert. We never knew how to do online teaching, and then we did you realize that we faced a huge divide, and that divide was knowledge divide, we had a skill divide, and we had a demographic divide. And that happened because of, as I discussed earlier, because of the poverty. And that 75 years of India is not a very long period, but at the same time is not a very small period also. We should have tackled with these issues. And that's why we have to keep in mind these issues for the future. Otherwise, tomorrow would be too late. And as Dostoevsky said, that everyone is responsible to everyone for everything. So it's not that we can't leave it to the government, or we can't leave it to the judiciary, or we can't leave it to the judiciary or legislature, that this is not my job. It is for somebody else to do it. So these are some of the contemporary issues which I'm discussing with you, which we need to, we are challenged and we need to face with. Now coming to the changing facets of law, I'm sure in these 5 days you must have discussed with a lot of changing facets of law. And to my mind, briefly, I will just bullet some points. Law has become a tool of economic development in the global world, and you know, from local to global is a big challenge. And the subjects like IPR, subject like international trade law, subject like international competition law, not competition, international competition law, merger and acquisitions, cyber law, ADR, now we call it ODR, because in the language of the artificial intelligence and the online age, Richard Susskind also says that it will become ODR. Artificial intelligence and law would be another very important area to come. Law and climate change. We have seen that what would happen if we are not sensitive to climate and we don't take care of environmental law. And somebody very rightly said that environmental rights are not simple rights. Environmental rights are emergent human rights. So we can wait for anything else, but we cannot fiddle with the environment any longer. So this is, and then law and climate change, as I mentioned, that you remember that if the temperature is rising, what can happen to many countries? They can be submerged in water in a few years to come. And then energy laws has become another important areas to discuss with, and the changing facets of human rights and the changing facets of fundamental rights. You have seen it, and I will not go in detail. Vijay is also there. He has to speak after me. I will only refer to Article 21. Just a very simply worded article, and to what lengths it has been sketched by the Supreme Court of India. And we have a long list of unenumerated fundamental rights, and that's what the changing face of law is going to be in future. With this, I close. I will not take much time. As I promised in the beginning, that I'm sure, and I also realize that you must be all tired for all these 5 days. So I thought that I will only bullet important points in the valedictory program so that you can further discuss it. And thank you very much for inviting me and giving me this privilege to speak on the valedictory. Over to Vijay. Thank you very much.
Thank you, sir. I would like to now request our guest of honor, Professor Dr. Vijay Kumar, sir, to say a few words.
As Professor Ranveer Singh was mentioning about lots of divides, India and Bharat, in the last couple of months, we are also seeing lots of divides. Students who would like to come to the campus and students who would not like to come to campus.
I know.
Students who would like to take online examination and somebody who would like to take offline examination. And students who would like to come to the campus but would like to insist on online examinations. Right? We have got too many divides. I think ours is truly a diverse situation, and that reminded me of something else which I forgot to mention, because I told you I was laying the foundation for telling you something about the appointment of judges, right? One important question that comes to our mind, which every one of us should ask, is why is it the judges, not many people are willing to take it? Yeah. Right? There are many lawyers who have got lucrative practices, winning money left, right, and the center. But if you ask them to become judges, they are not willing to become judges. Right? What is the reason? I was also trying to analyze why this, it's an honor given to somebody to become a judge, and why somebody is refusing. Is it for money? Possibly yes. Right? Because paisa hi sab kuch hai. Paisa hi Bhagwan hai. Right? In this situation, we need to look at it. We cannot blame them. I would like to bring some comparison so that you can understand why I am saying this. When the Constitution came into force on 26th January 1950, the salary of the Chief Justice, do you know how much was it? Salary of the Chief Justice of India. If I tell you, you will not believe me. Right? It was 4,500 rupees. And other judges, 4,000 rupees. The Chief Justice of the High Courts, were given 4,000 rupees and other Pune judges getting 3,500 rupees. There were judges who were to, go in a pool, carpool, right? People coming from one direction or one locality. 2 or 3 judges will sit together in the same car and used to go to the high courts, right? Now gone are the days. Now on 26th January 1950, the salary of a sub-inspector, just for the sake of comparison, was somewhere around 100 rupees or 150 rupees per month. You may not believe it. When I joined my academic career way back in 1978, right, my salary was 400 rupees basic. All other allowances put together, it came to around 968 rupees. I very well remember my first salary, right? This was in 1978, right? Now, with the 7th pay commission coming into picture, I never thought when I joined Presidency College Madras that I'll ever see 5-figure salary in my lifetime. But see, from 1978 to 2018, or even much before, the salary that I am getting is 2 lakh, 26,000 plus other allowances, whatever it is. When 7 pay commissions have enhanced the salary of a sub-inspector, I think some of your friends may also be working in the police as sub-inspectors, and ask them what is their salary today, right? I don't think it is less than 30,000 rupees or 40,000 rupees with all other allowances put together. Now, when 100 rupees or 150 rupees can become 40,000 rupees, see the manifold increase in the status of a sub-inspector of police, or you can compare it with any other salary scale given in this country. The salary of the judges has not proportionately increased, right? There have been only 2 increments so far, right? Now their salary is around 2,50,000 or 2,30,000, whatever it is, plus other allowances like free car, bungalow, assistance, so on and so forth. So if you look at it in terms of the increase, 4,000 becoming this 2.5 lakhs and 150 rupees becoming 40,000 rupees, that speaks volumes about the proportion in which the salary has to be increased. If that salary is increased accordingly, because it requires that type of ability, so that you are not talking about the financial constraints for the family, right? Then you can attract many people who can come to judiciary. And we are not willing to do that, and we are not willing to do the other things as well. So I think I forgot to inform you about the dilemma that we have in choosing the judges, and why rich lawyers would not like to become judges, right? This is maybe a part of my understanding. I may be wrong. Now, let me very quickly, as part of a few observations I would like to make. Somebody went to the Harvard Law School Dean way back in 1984 and asked him the question, why is it that your law school is #1 year after year? He gave 3 important points, which I think all of you should ponder over. The first one is critical thinking. We develop critical thinking among students. You please ask the question, are we doing that? Simply saying that we are the Harvard of the East, right? We are better than Harvard does not take us anywhere. But are we making the students to think critically? Come prepared, prepared to the classroom. And the teachers go to the classes prepared. Entertain a dialogue. How many of us will take the questions? I have seen many teachers, they will not entertain any questions asked by the students. If somebody asks, then they will just subdue them by scolding them, by threatening them, and so on and so forth. So we don't have a proper atmosphere in which a teacher is also a learner and there may be wonderful questions coming from the students. If at all today I am speaking with a little amount of confidence in constitutional law, I would give 1/3 of the credit to my own students at the Law School Bangalore between 1988 to 2018. They never allowed us to get out of the class without questioning us, and not ordinary questions, questions that made us think, that made us read a lot more, that made us to look for information from outside the books, right? And when you try to do it, the students also get the evaluation done properly and effectively, right? And I don't think when we teach in a cooperative manner constitutional law and administrative law in the law school, the students in their evaluation wrote that the teachers made Sirvai, which is the classic text in constitutional law, look like a market notes. So which means you make them think, make them look for information and be satisfied, and you're able to say that the Supreme Court is wrong on many occasions, right? And let me tell you, Justice Krishnaiah, right, when he delivered the last lecture at the law school, was grilled left, right and the center by 80 students of the second year course, right, about Samshay 6 judgment, keeping the text of the constitution and asking him why did he write the judgment which he wrote in that particular judgment. He had no answers, right? So that is what is called as critical thinking and looking at, and simply by saying rule of law will not come on its own, right? So that is the first one which we need to ask. And when you ask this question, critical thinking, right? Number one, whether we have the critical thinking ability. Number two, whether we facilitate critical thinking in our classrooms, right? If you carry these two questions with you before you enter each and every class, I think there will be a drastic improvement in your own standing, in your own appreciation, and the respect that you command from the student body, right? It is not covering the syllabus prescribed by the university. As somebody used to very jovially say, uncover the syllabus. It is not covering the syllabus, you have to uncover. Whatever little you do, you go deep into it. That is the best way of developing the analytical skill or the critical thinking that the Harvard Law School Dean was mentioning. And therefore, there is what you call it as specifically the role of teachers. And the very objective of this faculty development program is to improve, right, that status, that smartness, that talent that every teacher should possess. And therefore, you must have come across certain role models. I had certain role models. I still have certain role models. I always regret that I don't have even 100th ability of Professor Devidas or Professor Ajappa. Dr. Ranveer Singh will know both of them, right? And one of the recently deceased Professor Visvesvaraya, right? So the command over the language, everywhere, somewhere the people dress, somewhere the people walk, somewhere the people interact with people, somewhere the people interact with students, right? All these things, there are role models. And I want every one of you to become a role model in one thing or the other in making a good students of law in your own institution. I think if you do that, the role of a teacher, not simply as a teacher in the four walls of the classroom, but the memory that the students will carry, right, beyond the classrooms, right? When one of the Indian presidents visited the Gulf country, the king, who used to receive people only in his palace, right, came to the airport to pick up Sharma, I'm sorry, Mr. SD Sharma, I think SD Sharma, Shankar Dayal Sharma, right? He was a teacher, and he happened to be now at a later point of time the king, and then president visited that country, and he came to the airport. The first visitor to be received at the airport was a teacher, and when the press people asked him, why did you break all this protocol, came for the first time to the airport, he said, I am not ashamed of saying this, he was my teacher, right? Not only he went to the airport, when the ladder was fixed to the aircraft, he climbed the steps to receive him from the inside the aircraft. not at the bottom. And the press people were very eager to find out. Then he said he was my teacher. And not only that, when he came down, he asked the driver to get away from the car and he drove the car back to the palace. And that is possible only when you are a good teacher. If he had come across a bad teacher, I don't think he would have done it, right? And imagine yourself as SD Sharma and then somebody somewhere, right? I think that is $1 million given to any teacher for the behavior of a student. And today I don't want that to happen, but at least when they see you outside the campus, right? They would have passed out around 10 years or 15 years ago, coming and saying, hello sir, how are you? I enjoyed your classes. I think the day is made for you, right? I think please identify we are able to stand up to that level, and it is not an ordinary job in the 21st century because the students are not the role models anymore, right? It is very difficult for us to maintain discipline inside the four walls of the classroom. Their mobile phones in the hand with all other gadgets, it is very difficult for them to listen to any teacher, however brilliant one may be, even for 30-40 minutes. So we need to change our ways of delivery of lectures to ensure that all the students interact with each other and interact with the teacher constantly. And if you are able to do that, then you set a very good standard for the teaching learning process of the 21st century. And when I do that, I mean, I added, apart from the 3 principles laid out by the Harvard University Dean, I have added 2 more, foreign language and ICT, right? And I hope all of you, or at least you must have come across the name ROSS, Ross, right? Have you come across the name Ross? What is Ross? Anyone?
Sir?
Ross, ROSS.
Red flower?
What is it? Empower.
Flower, sir, flower.
Oh, no. It is not flower. ROSS is the name of an AI-based robot, right? Please, you can Google search, you will get it. Watson Group of IBM created this, and he is the first employee of a law firm in New York, right? What does it do today? This law firm has hired this Ross, called as Ross. The lawyer walking in will say, good morning, Ross, I have a case on motor vehicle accident. I need the inputs. By the time he takes 3-4 steps, goes to his chamber, sits in the chair, all the details are collected. The existing details are collected by Ross. And that much of information is pumped into the lawyer's desk. Not only that, what is happening around, up to date, up to that minute, up to that second, all the data are collected and given. And that's why I said AI-based robo. So the lawyering today, and then I think this pandemic only hasn't it, right? Online courts, this and that. So therefore, we need to look at, are we able to produce these lawyers who are also equally capable of looking at the developments in the ICT, not now, in the next 5 to 10 years, right? For example, ADR, online dispute resolution, right? These are the areas on which we need to look at it and make them take interest. Otherwise, traditional constitutional law, international law, and other areas, I think that the day is gone. Because when I was a student at Madras University, the teachers used to prescribe a syllabus and prescribe one book. And that book will not be available in Madras University at all, right? And even if there is one book available, that is always with the teacher. So it was basically information passing. There was no Xeroxing. There was no clicking of the pages by your mobile phone. There was nothing, right? So you have to be at the mercy of the teacher, sit down in the class and meticulously take notes, right? Even interaction के लिए time नहीं था, right? Today, the more the students know, we become smaller and smaller before them in the classroom, because information is available. Whatever information you want, whether it is in law, social sciences, science, technology, whatever it is, right? Everything is available. So information passing is not the only job of a teacher anymore, right? It may be incidental to the job. And therefore, the teacher has to look at the situation, the scenario, and create the proper and necessary academic environment. And when I say proper and necessary academic environment, an academic environment, this is also my own definition, an academic environment where the teachers go with the intention to teach, and the students also go there with an intention to learn. I think that is the best academic environment. And I don't think anywhere in the country today or anywhere in the world today, because of the pandemic, this situation is available. Our job as young teachers, the onus is on you to see how best we could increase our abilities to make the academic environment robust in one sense, so that we can maintain the standards of teaching in the country in the years to come. Finally, in teaching law today, the interdisciplinary approach to the study of law, we have been emphasizing right from the beginning, but I think seldom practiced in the law schools, including the Bangalore Law School. The National Education Policy 2020 has emphasized and overemphasized the need for multidisciplinary approach to the analysis or the study of any discipline, any subject. And therefore, we need to look at the teaching of law from various other dimensions, taking inputs from different disciplines. It may be social sciences, humanities, science, pure science, right? Communication technology, air and space technology, whatever it is. Ultimately, everything is regulated in this 21st century. And if we have to know that, we should also know the trade better, right? I was a student of Madras Law College, and there used to be a lawyer who was not a doctor, right? He was a hardcore criminal lawyer. If that lawyer went to cross-examination to any court, the doctors used to fear him because he had thorough knowledge about the incident, thorough knowledge about the medical and other related subject matters, as competent as an expert in medicine would require. And that is the competence that we need to develop in the student community. Are we ready for that? I think the world will tell us time has come. If you are able to do that, I think you will develop the standards that are necessary for maintaining and attracting students from abroad, right, to this country, right? And therefore, the new education policy speaks about multidisciplinarity approach, internationalization of education, right? That's why I said foreign language will be always an asset. The quality of higher education, minimum regulation, maximum governance, right? These watchwords we have to keep in mind and try to see what can be our contribution to the 21st century higher education, so that whatever Professor Ranveer Singh was mentioning, to achieve that sustainable development goals by 2035, right? With this observation, maybe sometimes I'm overstepping the limits of saying something or the other, but in the larger interest of the teaching learning process, right? Please bear it in mind. And then my apologies if I have hurt somebody's feelings, right, in saying something. And thank you very much for the wonderful opportunity that you have given, right? Good evening to everyone.
Thank you so much, sir. I would like to invite.
Yeah. Professor Ranveer Singh is trying to say something, but he is muted.
Yes. In the meanwhile, I would like to invite our officiating dean and head of
Delhi,
department.
Vijay, I'm just saying bye-bye.
Okay.
Okay.
Thank you so much, sir, for your presence.
Thank you.
Yes, for the conclusion and vote of thanks, I hand over the mic to Professor Dr. Komal Odich, who is the officiating dean and head of department, Faculty of Law, SRM University. Ma'am, you are on mute.
Is it clear
Yes,
now?
ma'am.
Okay.
Yes, yes.
So good evening, everyone. I feel privileged and honored to propose vote of thanks on behalf of Faculty of Law, SRM University. I convey deep regards and hearty thanks to the Honorable Chief Guest, Professor Ranbir Singh, sir, for gracing the valedictory ceremony. And we have immensely benefited by his vision, what he just discussed of developing new culture, mandate of law institutes to evolve new jurisprudence to get justice to all, especially what we have recently gone through the recent pandemic. But somewhere we have to hasten this process. And the other contemporary issues, what he discussed about the climate, artificial intelligence, definitely, sir, we'll soon have another FDP where we'll be able to have deliberations on such contemporary issues also. We are always greatly encouraged and motivated by your presence, sir. Thank you so much for taking out time from your busy schedule and hope you will do so in future also. My heartfelt thanks to guest of honor, Professor Vijay Kumar, Honorable Vice-Chancellor, National Law Institute, University, Bhopal, for his gracious presence at this valedictory function and giving his invaluable time for the very enlightening, informative last session of the FDP. And he just now, discussed another aspect in continuation of that why people are refusing to become judges. Another invaluable guidance, what he has given us, that there has to be critical thinking that is required to be developed in the students, and teachers should always remain a learner, ask the students to think, look for information, felicitate critical thinking or analytical analysis. Sir, we promise you, we will become role models for our students. We'll have more interactive classes. And what you just discussed about interdisciplinary approach, you will be delighted to know that, when we last year drafted the curriculum, so Professor Paramjit Jaswal was very particular that we have this interdisciplinary approach also. So we have now in the curriculum artificial intelligence and law, then we have IoT, and then we have big data analytics and all. Thank you so much, sir, for your invaluable guidance and time also. The greatest leader is not necessarily the one who does greatest things, but who gets the people to do greatest things. Yes, I am referring to Honorable Vice-Chancellor, SRM University, Professor Paramjit Jaswal. Because of his official preoccupation, he has not been able to attend this function, but I am extremely grateful to him for his support and guidance to organize this event and always encouraging us to strive for the best. My deep regards and thanks to Professor Samuel Raj, sir, Registrar and Dean Academics, SRM University, for his unflinching support for every event held at this Faculty of Law and always showing cooperation at every hour. Thank you so much, sir. My sincere thanks to Professor Manish Phalla, Director Campus Affairs, and Manoj Kutty, sir, Director Administration, for their cooperation also. I extend my hearty gratitude to all the distinguished resource persons for not only giving the scheduled time from their busy schedule, but also unscheduled also, as every session extended beyond the time limit. Their patience to satisfy all the queries raised with patience and elan. Since I have to give the concluding remarks also, I know Ranbir Singh sir said it is the valedictory function, everyone is exhausted, But somewhere I think we have to go through what we have learned in all these last 5 days. We know that this 5-day-long event consisted of 10 sessions, having deliberations on the topics related to contemporary legal issues and changing facets of law. The FDP was to promote the professional development, to update and refresh the knowledge of the teachers and scholars regarding the theme of this workshop. It was somewhere also to motivate the faculty to achieve effective and quality teaching and learning environment to strengthen the educational standard. The first session we had on the role of academia in shaping the next generation advocate, and the resource person was Professor Dr. S. Shanta Kumar, Honorable Vice-Chancellor, Gujarat National Law University. He was also the Honorable Chief Guest at the inaugural function also. Very aptly, he divided his session in 3 parts to who is the next generation lawyer, what competencies are required, how would law teachers impart these skills to the students. He pushed new generation educators to be aware of new changes and developments in the society and in the new generation learners. He highlighted how legal practice is changing in recent times, with only a few law graduates now opting for bar, while others predominantly prefer some other profession. So he urged the teachers to adapt to these changes, to equip themselves how they could help their students to acquire the new skills for these employabilities. He opined that we need to constantly hone our skills to match the evolving expectations of the student in the class. In fact, in a very interesting way, he shared his own experiences from classrooms to suggest ways to make learning interesting. And he suggested the use of andragogy instead of pedagogy, because he said pedagogy is to teach young children. We are here to teach the adults in law institutes, and the institutes must encourage to set up incubation cells also to support students with new business ideas, promote entrepreneurship, etc. On the same day, session 2, the resource person was Professor Vijay Kumar Singh, Dean School of Law, University of Petroleum and Energy Studies, Dehradun, and the topic was regulating big tech. He began the session by introducing the concept of big tech, referred major technology companies such as Apple, Google, Amazon, Netflix, Facebook, and he explained how these entities have made the market, how they dominate in the market, how they shape the market values, and they have become the gatekeepers who regulate the interaction between consumers and service providers. Of course, he talked about that these companies are data-driven, large-scale consumer-facing technology platforms they provide market and informational infrastructure for a digital society, and of course, perform essential civic functions also. But he also talked about the lack of regulation for these big tech companies, concern about the privacy, and huge awakening which is required for the future of these large tech companies. So he was very much concerned about the areas which need regulation, like cyber safety, competition, algorithmic collusion, and interference to the extent that in the government decision making also. Day 2, first session was devoted to complete justice, COVID-19 and Constitution of India, and the resource person was Professor Emeritus Dr. Balram Gupta, Director, Academics, Chandigarh Judicial Academy. And he commenced the discussion by enunciating different challenges that have been posed to the humanity by this pandemic. And he went on to say that complete justice is like natural justice. He discussed that the power of court under 142 is very wide and can formulate legal doctrines to meet the end of justice. And he explained that this article has stood the test of time during pandemic also, by providing the access to the courts or directing the state union territories to constitute high power committee in the cases where the trial prisoners could be released temporarily, and even extending the period of limitation. So he said that Article 142 incorporates constitutional morality also, which is the precious gift of judiciary to the people. The day 2, session 2 was on smart contracts and blockchain technology. This was conducted by Professor Dr. M.K. Bhandari, CEO, Infinity Law Tech Educational Services, Hyderabad. He discussed extensively the history of blockchain from 2006 to the present date, and the distributed ledger technology, basic characteristics of blockchain technology, types, application, advantages, and challenges also in the present time. He also explained the relevance of blockchain for government services, CBDC, and the provisions relating to smart contracts. He explained elaborately the definition, uses, logical, technical, economic aspects. He expressed the need for a comprehensive legislation for regulation of smart contracts. And he said the digital transformation is the new mantra. Day 3, session 1 was on the rise of feminist jurisprudence and its implications on contemporary India, and it was conducted by Professor Dr. Rajesh Gill, Department of Sociology, Punjab University, Chandigarh. She highlighted the social issues which change from place to place as does law. And that is why she said law and sociology go together, since law is also contextualized in society. And the scientific construction of law was questioned by feminists, highlighting that all aspects of the society were formulated as males, simply including that in that women also. The inherent biases in law and society which did not allow women a place as a matter of right, but only as an afterthought, were also identified and called out. She discussed numerous social legal issues such as restitution of conjugal rights, marital rape, sexual assault, rape laws, domestic violence, live-in relationship, reproductive rights, triple talaq, etc. She spoke of how awareness and education is more important to change social perceptions and ground reality. Day 3, the same day, session 2 was on the patents law and public health. And the resource person was Professor Dr. V.K. Ahuja, Vice-Chancellor, National Law University Judicial Academy, Assam. The distinguished guest opened the session, by comparing COVID-19 to Spanish flu in relation to the precautionary measures and unavailability of the vaccines. He explained the historical evolution of right to health, its constitutional perspective, and related international instruments, especially TRIPS agreement and WTO. He further explained the historical evolution of the Patents Act 1970, the Doha Declaration, and how India became a member later on of the Paris Convention. He explained the licensing of pharma companies, compulsory licensing system, and lastly, he discussed the TRIPS waiver for vaccines. Day 4, session 1, online dispute resolution, taken by Dr. Anand Pawar, Professor of Law at Rajiv Gandhi National Law University, Punjab. And he also discussed the various advantages of ODR, provided a solution to resolve electronic commerce or interrelated disputes which are cross-border in nature, and how it is still evolving. And he did the comparative study with different countries. And he discussed the initiative which can be taken to discuss all the legislative efforts for concerning ODR. And the same day, the challenges before the banks and the IBC 2016. This topic was taken by Mr. D.D. Sharma, visiting faculty at SRM University, next general manager for Punjab and Sindh Bank. And he discussed about the banking system, importance, speciality in the developing country, how this generation of entrepreneurs need the help of banking system, but somewhere it has led to increase in the risk of banking system. These entrepreneurs experiment at the cost of the banks, and he said if the banks are healthy, the economy would be healthier, and economic growth would be higher if it is done so. And he gave the overview of the IBC 2016, its impact on the economy, and last not but the challenges before IBC. Day 5, we had the last day today, Transformative Constitutionalism, the topic taken by Professor Dr. Nishtha Jaswal, Vice-Chancellor, Himachal Pradesh National Law University, Shimla, with a detailed overview of the topic. She talked about that Constitution is not merely a book, but a living document as it needs to the, it caters to the needs of the society and the welfare society and justice, the dominant goals to be achieved through this. So she elaborated the concept of separation of power, rule of law, and finally she conducted with the statement that the transformative constitutionalism is possible when judiciary is independent, fearless, and honest. And the last session was taken by Professor Vijay Kumar, our guest of honor today. The appointment of constitutional court judges, need for an overhaul. He divided the lecture in 3 parts: appointment, tenure, and post-retirement. But he started the session by saying, who will guard the last guard? So the judiciary, the last custodian of the Constitution, its power is to be checked. Somewhere the judicial independence he differentiated from the independence of judge. Separation of power he discussed. Then he also discussed about the accountability of the judges, the impeachment or resignation, where somewhere it has failed to ensure accountability. So independence has to be maintained. And he discussed about the appointment of judges in 4 periods and how significantly all those periods have contributed. So this was the last session taken by Professor Vijay Kumar. I laud the efforts of the conveners of this event and all the faculty members for making this event a success. My sincere thanks to both the faculty conveners of this FDP, Mr. Hartesh Kochar and Ms. Ashwati. Of course, to the other faculty members also, I extend my thanks for their unlimited support, and thanks to the IT department, Mr. Kaushik also, for his contribution to conduct this program. I convey thanks to all the distinguished participants, as they had really shown active participation during last 5 days. There is always a huge need for organizing such events on regular basis, and such kind of training programs are very, very essential for professional development. But I urge all the faculty members who have participated in this to perform their duties sincerely, honestly, and incorporate whatever we have learned in this FDP, as the future of our nation is very much dependent on us, the kind of quality of teaching and learning process we impart to our students. Thank you so much. Over to you, Hartesh.
Thank you very much, ma'am. Hartesh is facing a little bit of a technical issue, so I'll take it from here. Thank you very much, ma'am. And a big thanks to you as well. This would not have come through without you. This was conceptualized by you and
No, I always say it's a team effort. It's always a team effort. And I am one of you. I also attended all the sessions.
Thank you very much, ma'am. Thank you, Vijay Kumar, sir. Thanks to all the faculty members, IT team, everybody. Ma'am and sir, with your permission, I think we could close the session.
Thank you.
Thank you so much, sir, again.